Welcome to JGL Law For You. JGL Law For You is a podcast by lawyers, but not for lawyers only. On JGL Law For You, we will be discussing a wide array of topics to help you navigate the many legal processes, developments in the law, other current events, and how they may affect you, your family, or your business. When we're back in the family law realm, folks, today with my partner and family law specialist, Chris Castellano. Chris has been representing clients all over the state of Maryland for the last 10 years, and we're here to talk about different ways to get your case resolved, not necessarily leaving it to someone who wears a black robe for a living, specifically ADR. Chris, welcome aboard.
David, thank you for having me.
So let's start with the simple thing. What does ADR mean?
Yeah, alternative dispute resolution.
Sounds like I should use that in our marriage, don't you think? It's an option. It's come up with some other way to resolve things. Never mind. You don't have to answer that question. So alternate dispute resolution. What is it?
Well, everybody does it all throughout their days, right? It's the interaction that you have with another person to resolve a dispute, right? That's the simple understanding of alternative dispute resolution. However, when it's in the realm of kind of the legal sphere, we put some additional guideposts to that. So there's a couple different flavors, if you will, of alternative dispute resolution, which we'll talk about today in more depth, but I would focus generally on the back and forth negotiation between two parties, a formal mediation session, arbitration, and what is actually within the court system of settlement conferences. Those four different kind of ideas.
So, Chris, before we get into the different aspects of the different flavors of alternate dispute resolution, it's alternate to trying a case and having a judge decide your case, right?
Yeah, absolutely. It's the opportunity for the parties to kind of control the outcome of their case.
Okay. So tell us for a moment, if you can, what exactly is the role of alternate dispute resolution and the different fashions, the different types of alternate dispute resolution, in specifically as it relates to a family law case?
Right. So let's talk about negotiation, right? Negotiation would typically be It's informal. It's informal in concept. It's one spouse with another spouse discussing it. This can be as simple as sitting at the kitchen table and talking about how to resolve their case and then going back to their respective counsels to say, hey, draft this up as an agreement. Or as formal as one spouse having their lawyer contact the other spouse's lawyer and trying to talk through different terms on how to resolve a case. Then you get into the world of mediation. Mediation is a bit more formal, right? Both parties have decided, yes, this is what's happening. We're going to have, we may or may not have lawyers retained at that point, but you're going to a third party. That third party is what we call a mediator. It should be someone that's certified, that's trained, that understands how to mediate, but you're going to that third party in hopes that they can facilitate a productive conversation between you and your spouse on how to resolve different issues. And then, of course, we have what I'll refer to as settlement conferences. That's, again, stepping up the formality ladder, right? We're in the court process. We've filed documents with court, and this is a hearing. The settlement conference is a hearing on your scheduling order when you go to court. And typically, let's say you've already had a divorce or you've already had a judgment. You're in the post-judgment world. A settlement conference could occur with a retired judge. But if you're not post-judgment, you could have another facilitator. It depends on the different court in which you're in, local court. But, generally what it is that it's an opportunity for the court to see, hey, is there anything that I can do to help you guys resolve your differences before you have to go and have a formal trial? And then finally, arbitration. Arbitration, and we could talk about that a little bit. Arbitration puts itself somewhat outside of those other three options insofar as that it's a form of ADR where you're giving the authority to a third party that's trained, certified, etc., and they can decide issues between you two without going to a judge in the formal litigation or trial process. So I do want to include arbitration, but it is somewhat different and separate from the overall discussion.
Okay, so let's just sequester arbitration out for just a minute. I'm going to ask you some about that, but let's talk about these other options in terms of trying to resolve a case. And let's specifically deal with cases that involve custody. So, you've got folks either that are in the process of separating and divorcing, either they filed or they haven't filed. I know what I do. I talk to folks about the options being, you can try to have input and impact on what happens with not only your child's life, but what happens to you and your spouse and your entire family for the rest of your lives. Or you can leave it up to some, and again, I don't mean to disparage folks on the bench, but you leave it up to judges who are generally overworked, underpaid, and have to move from one case to the other. So what do you say to folks as you discuss options, both prior to litigation and during the course of litigation? Options, and again, I want to talk about arbitration separately, but options to trying to get your case settled, and how do you decide what to recommend to that client? What might be the best way to go? Do we wait for a settlement conference? Do we let the court tell us to go to mediation? And we'll talk about what the rules about that in a moment. Or do we pick somebody ourselves? Or if in some cases, I presume you also talk to folks about them going without lawyers. So there's a lot of questions built in there, but give these folks a backdrop in terms of strategy, in terms of what your thinking is as you're looking specifically as it relates to a custody case.
I'm going to give the most lawyer answer possible, right? And the answer is, it is that every case is very specific, fact specific as to, the best way to resolve it. But, and you've practiced longer than I have, but since I've begun my practice, I can count on one hand cases that absolutely require going before a judge to be resolved, right? I would think that at some process throughout a case, almost every single one of these cases can be resolved in a form of negotiation or mediation. And I think that that's somewhat in the legal sphere unique to family law cases, because these issues are all generally very personal to the people. And, you hit the nail on the head, and we've all heard the speeches from, members of the bench of, you bring a case before a judge who has never seen the facts before, doesn't know your kids, doesn't know you, doesn't know your house, doesn't know any of the facts relative to your family, and you want that person to decide the outcome of the rest of these people's lives forever. It is abdicating that power to a third party who has no idea about your specific circumstances. That is a very, very powerful motivator for people to understand. I think that I would like control. I would argue the human condition is one of asserting control over your surroundings, right? And the idea of abdicating that very essence of control is somewhat astounding if you think about it. And so, I think that mediation offers the ability for people to at least gain back some of that control. You're not going to gain it all back, right? Because mediation, negotiation is inherent of give and take. But when it comes to advising my clients, how do I approach it? It's with all of that in my mind as a backdrop, but I've always seen myself as a risk manager, right? And when you do a risk analysis, whether it's early in the case, late in the case, in the middle, it doesn't matter when, you're analyzing, okay, my client, what is likely to happen if you go to court? What's the default outcome if you go to court? If I can get you one more overnight, one more dollar, one more XYZ in mediation, and you save all those attorney's fees, that risk analysis kind of is common sense at that point, right? And it's all about relaying effectively that cost benefit risk analysis to the client. And again, I find it very hard to justify throwing the pen down on the desk and saying, let's just go to trial, right? Because most of these people at their very core, they want to assert that level of control that the court process kind of takes away from them.
Especially if it comes to parenting your children. It's one thing to talk about money, I think, there's a possibility that you'll get X or Y in terms of finances. But when you start talking about your kids, it's definitely a lot more personal than a breach of contract case or something like that. And I think What I'm hearing from you is that you try to make people understand that this is these are life decisions. These are not just, business disputes or personal disputes with your neighbor over a tree or whatever the case may be, right?
Oh yeah, absolutely. I mean, you bring up a great analogy, right? If you've got an issue that property dispute with the tree, you're oftentimes not going to find a happy middle ground in that issue. It's either X or Z, right? And when you've got
You're chopping it down or you're leaving it up.
yeah. And so it's easy to abdicate that type of, okay, you know what, judge, we can't see eye to eye, either chop it or keep it. And so you just play the Solomon role, right? But when it comes to families, I think that you're, again, hit the nail on the head. This is the most personal aspect of someone's adult life. It's a fundamental right that we have, is to parent your own children. And, I think that people place, rightfully so, a very high significance on that. And so controlling that outcome, I think, is extremely important to them.
I mean, I'm going to date myself a little bit, but back when I started doing this work, the reason I started doing family law was because you tried cases all the time. Long before you showed up on the scene, Chris, we tried cases over child support when the difference was $20 a month, $50 a month. But what it did for the lawyer, for me, was, okay, I'm up in a courtroom. And that was the reason. It wasn't because I decided my life's work should be family law, but it was trial work. Whereas today, and we're going to talk about it in a minute, there are rules and requirements that people actually have to go to some sort of alternate dispute resolution. And we didn't have that back in the 80s and certainly well into the 90s, maybe early 2000s. I can't remember. And I'll tell you a funny story about this lack of control. We had there was a judge in a local jurisdiction who actually, for a period of time, was affiliated and a partner at the law firm that you and I are now shareholders at. And this fellow would come up on the bench, and before every custody case, he'd say, "Hi, my name is Judge X." I won't say his name. "I was appointed by Governor Y." I won't say his name either. "And my job today is to make a decision between 9:30 and 4:30 with an hour break for lunch to listen to you testify and listen to your witnesses. Then I'm going to make a decision that affects you and your children for the rest of your lives. And then I'm going to go hit a bucket of golf balls and never think about you again." And that's a stark reminder. But I think that, and we can fast forward to 2025, but your judges are busy, right? I mean, they got lots of cases to have to deal with, right?
Oh, absolutely. And it's not just family cases, right? I mean, they're bouncing from, depending on who you get, of course, and which courtroom you're in, or in courthouse, they're bouncing from different types of issues. They don't have time to really dive into, the lawyers and the clients have spent months, if not years, developing their case, getting into it, every single nitty gritty detail of their case. And then you've got to go and distill that down to sound bites for the judge to be convinced that, well, yeah, person A as opposed to person B should have, exclusive control over this 6-year-old child for the rest of their life, or for the rest of their minor life. It's wild. I absolutely agree. And you bring up the point of the change in practice. Thankfully, I would say it started with law school for me. When you go into law school now, it's the collaborative and mediation-focused approach to litigation is drilled into you from day one. That orientation when you're in the auditorium as a first-year law student is cases should be resolved through mediation. This is a systemic transformation of how the practice of law works, and ultimately, I think it's certainly a net gain to the clients, at least in the field of family law.
Before I get to one question, and again, I'm excising arbitration for the moment. Are mediations? What if I'm in a mediation and you and I are talking, or I'm talking to the mediator? Is that confidential, or can that mediator? What if we don't settle the case? We end up going to trial. Can the mediator come and testify to what I said during the course of mediation?
Yeah, the whole mediation process, and specific to mediation, that is confidential. And so, people should feel rest assured that, at any point in the process until the gavel drops, they can attend a mediation, and that process is confidential. It doesn't go back to a judge. So they're not going to be prejudiced that, hey, I was willing to do this, or I said this in mediation. Is that going to come back to bite me? The answer is no. You should feel confident, safe, and open to explore different areas to resolve a case.
Okay, now, and you talked about sort of the transformation from sort of everything geared toward litigation and now things much more geared to a different way of resolving things or an alternate way of resolving things. There's actually rules in the state of Maryland requiring alternate dispute resolution, right?
Yeah, that's right. I mean, for your general case, and when I say general, I mean the cases that don't have unique issues such as domestic violence or abuse or other issues like that, there's requirements to attend sessions of ADR. So, for instance, in Maryland, for contested custody cases, right? You're going to go to your scheduling conference and you're going to attend a child custody mediation. And if you have lawyers, the lawyers will be required to also attend.
Tell me for a moment the difference between arbitration and mediation. What is arbitration versus mediation?
So you could think of arbitration as a pseudo trial. In lieu of going before a judge and having the typical rules of evidence that restricts lawyers and how different pieces of evidence or testimony comes into trial, you can go to arbitration, and an arbiter is agreed upon by the parties to preside, and that individual will hear both sides of the case. You're going to present it in the same professional manner as you would a trial, essentially, but you're going to have an outcome that is binding on both parties without having to go through the process of, the full trial.
Well, I mean, if you're putting on evidence, right, you're having people testify in an arbitration, right? And you're putting exhibits in an arbitration, just like you would in a trial, right?
Right.
And you have to prepare for the arbitration, just like you have to prepare for the trial, right? Why would I decide to go to arbitration? I mean, what's the difference? Why not just go to the courthouse and do it that way? I mean, aren't you paying the arbiter most of the time? You're not paying a judge, so why should I do that?
I will tell you that in the family law sphere, arbitration certainly isn't the most used. It's not the most popular ADR method, but there's benefits. There's benefits to ADR, and again, that lawyer answer of it's specific to each case. Let's say you have a very complex money case, right? Post-judgment perhaps, but it's a very complex money case. And so you want an arbiter that's got some significant experience in several businesses between the parties, whatever it may be. But you want somebody that can resolve the dispute between you and your spouse that has an intense level of experience in that area. Generally speaking, arbitration is also quicker. It's a faster process. Yes, you're paying the arbiter, but because it's quicker, it can end up being a net cheaper prospect. So there's a cost effectiveness aspect to it. Because it's not as formal as trial, you're going to have a bit more flexibility. Both the arbiter will have flexibility in the types of ruling or outcome that they can offer. And again, going back to, ultimately why you would pick, certainly why I would pick an arbitration over trial, is that you can select an arbiter that has that specific type of expertise that you're looking for.
For anybody out there who's had to go to a courthouse, there often is a lot of waiting involved when you're in the midst of litigation, waiting for your case to go on, right?
You and I have both had several trials where, you get all gussied up and you're ready to go to trial. And the next thing you know, you're sitting on what's called TBA and your case gets punted for another 4 months.
Yeah, and whereas with arbitration, you're picking the person to make the decision, and you're also picking your date that is whether it's taking place in a lawyer's office or law library or a courtroom or wherever it is, you're going to go forward on that date. So there's some benefit to that, I assume.
Yeah, there's benefit to the certainty that, hey, I'm going to have a resolution of this case today or throughout that process.
So if I'm a litigant and I'm talking to you, what's our discussion? What's it going to look like if we're trying to figure out okay, I'd like to try to find a way to resolve this case outside of, having a judge make the decision. Or frankly, again, let's excise arbitration out of this too. What's our discussion look like if I'm your client and you and I are trying to figure out the best way to work toward an alternate resolution that doesn't involve a judge making the decision?
Yeah, so what I like to do and how I start with it, looking a little bit behind the curtain here for me, is, what I like to do is have the client tell me, what's your bottom line? What's the bottom line that you would like to see out of this case? And then alternatively, what is your perceived best day? What's a home run for you out of this case? Right. And once you establish that spectrum of expectation for the outcome of your case, then you can start to operate within that, because there's inherently going to be a spectrum of outcome by the other party. Now it's not going to match up, of course, because if it did match up, you wouldn't have a dispute, right? But the idea is, how can I align those two spectrums in a way that can result in an amicable resolution of the case? So step one, figure out where we are, or where the spectrum exists, okay? And then figure out, how is it that we can communicate your desires to the other side to see if there's any middle ground. And that's where the skill of negotiation comes in as a big factor.
Again, if I'm somebody, I'm trying to decide what to do. I know I'm on my way out. My marriage is over. I'm not sure what to do. How's it going to work? Am I going to end up going to trial? Is there some other way to settle things, resolve things? What should those folks who are at that stage, and there's a lot of them out there, what do you tell them in terms of taking that first step to try to figure out their best plan?
Yeah, I mean, I sit down with them and say, what do you want out of this case? Do you want to spend $50,000, $60,000, $70,000 to go to trial, or do you want to control the outcome? And a lot of the times it's about calibrating the state of mind of that individual, that party, right? Because in a lot of ways, the state of mind is not yet there. They're in a fight or flight type of mode, a lot of these people. And so you need to channel their energy in a productive way and say, we can get you to where you want to be, but you've got to understand where you want to be and the best way to get there and how much it's going to cost. There's a couple different factors that play in, but once they can get there, I think that, they're in a good place.
Why should someone give you a call, some other family lawyer, who's experienced in this kind of stuff, versus just picking up they almost said the yellow pages, that really is going to date me, looking on the internet and just picking any lawyer to kind of help me work things out? What's the benefit? Or is there a benefit to calling somebody who's used to doing this kind of work? And it sounds like I'm giving you a softball question, but I'm really not. So, there's a lot of folks out there who do a lot of things. So what would be the reason to call someone who focuses, like you do, focuses their work on family law?
Yeah, I mean, you and I had a podcast a few months ago about the rise of AI, right? One of the things that we talked about there was, what's the benefit of going to a family law lawyer, experienced lawyer, versus just simply creating an agreement through ChatGPT or Copilot or whatever it may be, right? And the same logic applies here, right? Is that you're seeking somebody out that does this on a daily basis, that sees these different issues, that's calculated the child support, that's calculated potential alimony, that's examined these issues, that, for AI, for instance, has to go through and learn X, Y, and Z issue, right? So understand why an individual will want to save, listen, if I'm going to save the money on going to trial, I'm going to save the money on going to a lawyer too. I'm going to do this on the cheap. The amount of times I've had people come back to me that say, Chris, you and I consulted. I decided to try it on my own with a mediator, and this is the situation. It's a disaster, right? I applaud people, frankly, for trying to resolve their differences in an amicable way, but it's fraught with danger, because one of the biggest issues that you can fall into is that you establish a basis for the negotiation discussions, right? So let's say party A, party B, they go to a mediator without counsel. and they're trying to do it on the cheap, and they try to resolve their case. And these people aren't family law lawyers. They don't know what should be or what could be an outcome in your trial. And so they turn around and say, well, I've got this agreement that now I want a lawyer to check out and verify if it's fair. And I look at it and say, I don't know what to tell you. This is way off base with what I would do. Right? But now you've created that spectrum that we referred to. You've moved that spectrum more in favor of the other party as opposed to you. And the ability to stretch that back out is incredibly difficult. And when I say difficult, that usually means incredibly expensive, right? So you've got to go through the process to stretch it back out. You got to pay money to do that. So the reason why I recommend people start with an experienced negotiator who, oh, by the way, understands how to negotiate is because you need to know how to maintain that spectrum in the way that benefits you best, right? And that means not capitulating at the first moment an arrow is thrown at you, right? That means, not allowing a mediator to force you into a box that you don't want to be in. Mediation is sometimes looked at as a very simple process, but it is just as much litigation as going to trial in a lot of ways. You're presenting arguments, and even without the guardrails of evidence and the rules of evidence. And so I like to think of it as Wild West litigation, right? Because I always prefer to use a retired judge, mind you, for my mediators. And we could talk about the benefits of different types of mediators, but I like to use a retired judge. And you're pleading your case to that retired judge, to that judge that used to sit on the bench. And you're giving documents that support your position, but you're doing it in a way that is a little more loose than formal trial. That's absolutely the case. But the other side's also doing that, or should be at least. And so that's why I say it's kind of the Wild West of litigation. But you need someone that's experienced that understands it. And there's an art to it.
There has to be, it seems to me. I mean, as someone like yourself who's experienced in trying to get cases resolved, not just try them, and like you said, each case has its own nuances. And therefore, someone like you understands, in theory, you talked about which mediators to use and so forth, that there might be mediators that are better for this case or that case. And that it seems to me does call for someone not to just jumping out and doing it themselves, but to contact you, Chris Castellano specifically, others like you, but let's keep them calling you. And if they want to call you, what's the best way to do that?
They can call the mediation whisperer of Chris Castellano, and I'm at.
Is that a website or that?
I'll think about making that a website. Okay. Mediation whisperer. JGLLaw.com. Christopher Castellano, 240-399-7881 can get me on the phone directly, and we can talk about your case and talk about how mediation can benefit you and your family.
All right, Chris, thanks as always for coming on. This is information that everybody needs to listen to. Everyone out there who is thinking of potentially separating and divorcing, is in the process of separating and divorcing, give Chris a call. And as always, this is JGL Law for You. I am David Bulitt, and thanks for joining us.